I first knew of Ramona because I knew of her father. Wayne Hage was a Nevada rancher who brought a big case against the federal government, the Court of Claims in Washington, D.C., with respect to his cattle's right to graze and use the water ditches on the allocations of land that he had possession of. And that case has been a long-lived case, 22 years in the courts. It has now prevailed. It's actually pending, though, before the United States Supreme Court. But the Hages have prevailed in that case, and have prevailed also in a trial in a separate issue before the Nevada courts. And so it is these two cases that have been the cause of the Hage family for over 2 decades. Wayne Hage was a man who was a very intense, intelligent, and profoundly communicative man. And his children have taken up that cause, and Ramona has done much of the same. Ramona Hage has been has attained status as an expert witness on forage rights, stock, water and irrigation rights, improvements, rights of way, and easements. She teaches seminars to property owners on this subject. She is the executive director of the Liberty and Property Rights Coalition.
It's good to be here. Thank you very much for having me, Debbie. Thanks, and all the family, for all of the folks that helped put this event on. And we were on some of the conference calls with all of you, and I just am so impressed with the level of organization up here in your part of the state. I'm a native Californian. We were raised in Sierra Valley, California, north of Reno, about 45 miles, and lived here till I was a freshman in high school. And we bought the ranch in 1978 in Central Nevada, Pine Creek Ranch. So I feel at home here. It's nice to be back in Northern California. Let's make a distinction there. And I also joke that my father and mother were very horrified when Jerry Brown was elected the first time and left California. But little did they know that they were going to Nevada to meet a different type of wolf in the name of the U.S. Forest Service and the BLM. So we jumped from the frying pan into the fire a little bit, but that's okay. We have, as Michael indicated, we have had a long-fought battle. A lot of you are aware of it, but I have some very good news along those lines. Our property rights are solid. We had property rights that people didn't know we had. We had property rights that Dad had to write a book about called Storm Over Rangelands in order to convince the attorneys, the rest of the ranching industry half the time, and the judges that those property rights existed because they all happened to be located on public lands, or what the government calls public land. So people were very skeptical that we even had property rights in the first place. So that was our first battle. And part of the reason this case drug on so long through the claims court is that we had to determine or prove to the court that we had property rights. But property rights don't go away, and that's what I want to cover here in just a little bit. But let me start with a couple things. As we are here in part, Liberty and Property Rights Coalition, a newly founded coalition with myself and David Spady, who some of you know. Danny Martinez is our CEO, and several other people involved. And our objective with that coalition is to come alongside other property organizations and property owners and help people deal on the front end, not wait till they're knee-deep in litigation, but front end of the property issue, and help property owners be effective. That's been a large problem for property owners across the West, is how to effectively defend those property rights. So we won't get into a lot of that today, but that is our objective, and primarily our main objective, because I will tell you flat out, When it comes to these agencies, they're usually operating outside the law. And as one person said, if their lips are moving, well, you know the rest of the story. Anyway, but you can start with that assumption. And that's where they're vulnerable. So anyway, I have some good news for you. I want to also emphasize, in my opinion, the successful defense of property rights. Individual property owners deciding to stand on their property rights and learning how to defend them. That will take some time. It won't be something done overnight. But learning how to defend those property rights is one of the best tools that we have in our arsenal to counteract this onslaught that we see in the form of wolves, in the form of dam removals, in the form of road closures, you name it, sustainability, all of these things. They have one thing in common. They're an attack on property rights. And for them to succeed with their agenda to destroy our constitutional republic, they have to destroy our property rights. And so the flip side of that is that the more effective that we are in defending those property rights, even property rights nobody knew existed 20 years ago on rangelands, the more effective we are in defending those property rights, I think, is one of the best tools we have in defeating some of these terrible programs that are being thrown at us. So I know everybody here is overwhelmed. You're getting it from all sides, but I think we have some good news. A couple things I want to housekeeping, and I think we have some things that are going to get handed out here first of all for you. Debbie, can you? Yeah, thank you. We are launching a new website. It's I won't go into a lot of details, but it's high tech, and it's going to have live feed news on property rights and agency news that'll be continually refreshed. And the technology is, as I understand, better than what Drudge has. So what we want is this website to be a one-stop shop for everybody dealing with these property rights issues, whether you belong to our organization or not, or you're another organization. We want to link up to all these other organizations that are doing great work, and be able to keep fresh property rights news from around the country on the website. Now, down below, and we don't have it on this screenshot, and this includes social media, blogs, and so forth. One of the things we all know from the mainstream media is we're going to have to be pretty creative in how we use the media. We're going to have to develop our own media, basically, and work around the AP and some of these other organizations. But down below, we will have a resource area for legal research, policy, and grassroots information. It will be a resource area that people can go to pull up anything that they might need in those areas. So if you can, there's a flyer being passed around. That's the website. It's not. It'll be probably up on Monday fully. But we just wanted to give you a teaser of that. There's also an email sign up here for our weekly newsletter called Liberty Scene. Some of you guys are getting it. And so if you see this form come around, go ahead and sign that. And finally, one of the things that Debbie wanted me to address, of course, is title work and preparing an exhaustive chain of title. And that's normally an hour-long talk. So I'm doing a shortcut on that. It's not complicated, folks. It's I've done a little write-up here that you can follow and go to the courthouse and prepare your own chain of title. It's not rocket science. And I was just talking to Debbie's family this morning and Debbie's mom, and they have their own title policy from the title company, and she basically has hers done. So anyway, I recommend that, and I'll tell you why here in just a minute. How many of you have followed HBUS or USD page? Okay, I can't. Okay, very good. I'm just going to tell you very quickly what we had happen in that case. As I said, we bought the ranch in 1978, and the problem started almost immediately. The Park Service tried to come in and buy the ranch. Now, the ranch is comprised of 7,000 acres fee patented land. That's land at 7,000 foot elevation. It's not alfalfa land, it's just pasture land. And then is made up of another 700,000 acres of grazing allotments. And what's important about that is, as is a typical Nevada ranches will not pencil out economically without their range allotments. We're entirely dependent on running on those range allotments. So the Park Service tried to come in and buy the ranch right after we bought it, but they only wanted to buy the 7,000 acres of deeded land. And my father said, well, that's nice, except for I think I bought a bunch of stock water and irrigation water rights out here. I have all these range improvements. I've got roads that we own. I've got rights-of-ways for ditches and pipelines. I think you might have to pay me for that too. And of course, he had just signed the note on the mortgage on the ranch, so he had a pretty fair understanding of what it was all worth. So when he didn't agree to be bought out, they then transplanted a bunch of elk on top of us without our input or knowledge, and started an escalation of a non-stop barrage of harassment and attempts to make it very rough on us to run a ranch. It escalated to the point that in one great summer grazing season, we had 70 visits and 40 certified letters. Visits usually included an employee, they're not officers, employee of the federal government with a gun, and then certified letters with some nasty ground about something that, some petty violation that we supposedly had done. Finally, in 1991, they confiscated 100 head of cattle at gunpoint. It was a paramilitary raid on the ranch. Dad showed up with a camera. There's an important point there. We've had friends that we've known get hauled off in leg chains with one of these encounters because they didn't keep a cool head. Dad was cool-headed. He took up the camera and asked those bureaucrats to smile real nice. And he did get hauled off in leg chains. They try to provoke you. They try to make you mad. And you need to understand that. So a cool head is important. So right after that, they filed the Fifth Amendment constitutional takings case, HVUS. A lot of you have heard about it. And 4 months later, they filed criminal charges against my father for clearing an 1866 Mining Act ditch right-of-way. Ultimately, the Ninth Circuit, he was convicted, and the Ninth Circuit reversed that conviction with a one-page ruling. But, you know, it's very odd for a law-abiding man who's pretty much a dot the I, cross the T's kind of guy as far as following the law to be peeing in a cup and wearing a leg thing and being under house arrest. It'll jangle your chimes. Out of that takings case, we had 8 published decisions, all in our favor. Ultimately, we had a $14 million judgment in our favor, along with attorney's fees. And the court found that we own the property rights that we had sought protection of, the range right, the forage right, the rights of ways, the water rights, and so forth. All of these rights occurring on federal land. And they ruled that, that it was a temporary taking, so we kept the ranch. Now that case is back to the... We had a minor setback at the Fed Circuit on a very narrow portion of the case. The vast majority, including all the property findings, are intact. But there's a minor setback on that. I won't go into a lot of detail. We did file a petition for cert at the Supreme Court. They denied it. And now we're back to the claims court for them to bring the case in line with the Fed Circuit ruling. One of the important things that the Fed Circuit said is that we had to be guaranteed access to our water. And you know, when you have isolated springs out on federally managed lands, that's always their caper, is trying to block you from accessing your water rights. So that should be done. We're very close to seeing the end of that. Very interestingly, my father and brother decided in about 2000, you know, they were starving, not being able to run that ranch. And then one of the issues that was left remaining from the claims court case was the issue of whether or not we could access our vested water rights and stock water rights and irrigation water rights without a grazing permit. They had taken our grazing permits and they had refused to reinstate them. But we had all these rulings saying that we had all these various property rights out there. So finally, my brother and dad kicked out cattle without a grazing permit. Now, first thing the government did, of course, is gnash their teeth and then try to, well, they continued the character assassination and called us outlaw ranchers, had most of the Nevada Cattlemen's Association convinced we were outlaw ranchers, and a lot of the state's politicians. But at the end of the day, as I told one of them and a friend of mine, I said, walk 1,000 miles in our shoes, what would you do? We had to force the issue. So in 2007, about a year after my dad died, they came at us with a trespass case. We talked about trespass just a minute ago. But there's a problem for them. When we had all these court decisions, we have all these vested water rights, we have something called pre-existing rights to be there. Our ranch was established just like virtually every other ranch and property, doesn't matter whether it's a farm or just patented parcel for other purposes, was established clear back in the 1860s. Around here it's 1850s or earlier. And we had what we call pre-existing rights. And we had, those ranchers had, our predecessors had settled the ranch, they had laid claim to the water under the prior appropriation water doctrine. That ranch had been bought and sold years before the Forest Service or BLM ever came into existence, or all these subsequent acts of Congress, such as the Taylor Grazing Act and the Federal Land Management Policy Act. So we stood on those pre-existing rights, and we made the claim that we can't be in trespass on our own range. Then we also filed a cross-complaint in that, alleging that the government had engaged in a long-standing pattern and practice to deprive us of our property rights and to interfere with our contractual relationships. In the spring, the entire spring, spread out over 3 months of 2012, we had a 21-day trial in front of Judge Robert C. Jones in the Federal District Court of Nevada. We had we produced over 47,000 documents or pages of documents for the federal government. We've been at this a while, so we're getting pretty good at it. And we figured we'd paper them for a change, so we did. We copied, out of the HBUS takings case, we copied 30 out of 50 file boxes from that case. We had 13,000 exhibits, and here's the important thing. We had 500 exhibits. It depends on what ranch or property it is you're talking about, but in our case, 500 exhibits and about another 50 or 70 exhibits on water rights, 500 title exhibits. And we got all of those admitted as evidence. Those were our exhibits on the title. Now, one of the result of that trial was this. Let me summarize very briefly. Our entire ranch was restored, and restored to its historical. And again, we're talking about these elusive property rights that exist on federal land that nobody thought could be defended, frankly. The court ruled that we had at least a half-mile forage right around and adjacent to all of our stock waters. Ruled that he adjudicated all the waters to us. We're the only ones with evidence of vested water rights. The government had no evidence, and they had no beneficial use of the water. They don't own cattle. He ruled that we had procedural and substantive due process rights to our grazing preference. I'll have to let you explain the substantive due process right, but the long and short of it is they can't just come and take our grazing permit or our grazing preferences willy-nilly like they did before. They cannot. That is something that we have a property interest in, although it doesn't raise to the level of a takings for compensation purposes. But they can't just come take it. He ordered the government to restore our grazing permits to their highest, or to their historical numbers. Remember, in these western ranches, typically the government has been incrementally cutting ranchers back over at least 100 years in some cases. And most people are down to about 30 to 25% of the original carrying capacity on these ranches. And they wonder why there's wildland fires. It is deliberate, of course. And he ordered us to obtain a grazing permit. We are now under permanent injunctive relief for this court. Instead of having to go through an administrative appeal, we go straight to the court. They cannot cut us more than 25% and then only temporarily, such as in a drought. And no longer can they send us trespass charges or impoundment notices unless they go through the court first. So not only do we have our property restored to its historical numbers, but we are no longer subject to their harassment. If they harass us and step out of line, the same thing for us. If there's an issue of contempt. I said, they have a culture of lawlessness anymore. And even the low-ranking employees within these agencies, whether they be federal, state, or even in these planning agencies and local county commissioners, there's such a culture of disconnect between the law and what they're taught that they may not know they're operating outside of the law, but so many of them are. And in our case, they ignored all those. They ignored water adjudication. They ignored the 8 published decisions out of the U.S. Court of Federal Claims. And they sought remedies outside of the court during the course of this trial, or this court case beginning in 2007. Some of the things they did was while they filed this case against us, they also sought trespass charges against people who leased cattle to us. They sent people to collections. I'm telling you, we had a good set of friends that stuck with us through some very difficult situations. They showed up with some of the people we did business with. They showed up with a federal goon, that's what I call them, and with a gun, holding their, ready to fire if necessary, to send notices and intimidate witnesses. So, anyhow, as a result of some of their, and then they sent out a solicitation to 70 ranchers in Nevada for our grazing allotment. They also brought in a guy who, by the name of Gary Snow, to graze on top of us during all this time, even though they wouldn't reissue our grazing permits. And they encouraged him to file on all of our waters. He not only filed on our waters, but he filed on our range improvements as well, saying that those were his. So anyway, they can always find a coyote to do their dirty work, but he was named part of the conspiracy. Let's see. Finally, about the 19th day of the trial, our best, by the way, our best help in the trial was the government's attorneys. And the best trial attorney at the trial was the judge. So he had some very great questions to ask, the smartest judge I've ever seen. Anyway, the judge had to stop the trial during the questioning of one of their attorneys of one of their witnesses, and ordered that man to hire criminal counsel because he wanted to protect his Fifth Amendment self-incrimination rights. And then that was the BLM manager down in Tonopah, and then he ordered the same thing for the forest ranger. So we had to stop the trial until they lawyered up and they found some bottom feeder attorney out of Reno to represent them. My husband's an attorney up there. I know some of these guys. Anyway, poor guys, they were not well represented. And ultimately, they were ordered to pay my brother, and they were found in contempt of court. Were found both civilly and criminally. They were found to have entered into a conspiracy to deprive my mother and father, and ultimately us, of our vested water rights and grazing preferences. To hear those words come out of a judge's mouth, sitting in that courtroom on June 6, 2012, I cannot explain what it was like to hear that.
Yeah.
So, they were ordered, the BLM manager and the forest ranger were ordered to bring their own checkbooks and write a total amount of $35,000 to my brother for restitution for some of the money that they had extorted out of various people. They have some problems. The judge made a finding not only of the conspiracy, but also findings consistent with what is necessary to bring forward a Bevins complaint. That is where you sue bureaucrats individually and personally. So we're looking into that, and we'll see what we do going forward there. We've been very fortunate throughout all of this, believe it or not. And you know, when Dad wrote that book, he kind of knew we already were in the crosshairs with the government anyway. This wasn't going to change anything, but he knew it was going to open up Pandora's box when he wrote that book. And kind of the discussion in my family was, well, our God is bigger than the U.S. government, so let's just leave it there. So this case has, if you look at a map of the western United States of all of the federally managed lands, virtually every bit of it has an adjudicated grazing allotment over the top of it, whether it's Forest Service, BLM, it doesn't matter. And that's the impact. That's the land this case impacts. Ultimately, if it's appealed up to the Ninth Circuit, then that'll be all the area of the Ninth Circuit. We don't know if they're going to appeal it. We haven't heard yet. And ultimately, we'll see what happens. But it's a vast amount of land, especially right now, 87% of Nevada is impacted by that case. So it has pretty tremendous and positive ruling. Now, for everybody dealing with water rights here, and you know, the same thing we did, or the same way we defended our rights is applicable here as well. That's the message I want to tell you. I have a little bit of background in doing title work for ranchers, and ended up being the expert witness for my brother on that case. And the reason you do title work is very important. As I said, it was the primary or the key evidence in not only the trespass case, it was the key evidence in the claims court case, and it was the key evidence in our Southern Monitor Valley water adjudication. Those 500 documents that I mentioned. They're very important. And the reason is when you do an exhaustive chain of title on a piece of property, whether it's patented land or a piece of property with appurtenance such as a grazing allotment and vested water rights and all the rest of it, what you do with that is you follow that chain of predecessors and interests back to the original settler, the original appropriator. And you bring your property rights forward. And I'm giving you layman's terms here because I'm not an attorney. But you, in essence, bring your property rights forward into your name from that original appropriator without the conditions that were in place in 1860 or 1850. They didn't have the Endangered Species Act back then. They didn't have the Clean Water Act. And they didn't have the Taylor Grazing Act back then. So then you put your property rights in a position of being recognized in their complete form from when they were originally appropriated. Every land law passed by Congress, and I would venture most state laws, there is somewhere in those laws is a savings clause. They almost have to have it in order to pass constitutional muster. And they cannot retroactively, and Danny will go into this in more detail, but they cannot retroactively apply the law backwards on your property rights. The problem is a lot of people go into court arguing about property rights and never bring the evidence of any property rights. And a warranty deed is not full evidence. You need that chain of title. So I encourage everybody to go ahead. It's something you can do yourself. And as I handed out, I encourage you to do that on your property. We are in the fight of, I think, the last however many years this country's been established, in 1776. I think we're in a very, very serious fight for the very foundations of this country, and I think defending our property rights is probably one of the best ways in which we can defend that constitutional republic. But it's the individuals that have to defend it. So I encourage you to go ahead and do your chain of title, get your evidence in order to prepare for whatever's coming and to be able to respond to it. The great news is that one of the people that we met along the way in about 2004, I think it was Danny Martinez. And my father had done all this research, wrote a book on what kind of rights we had out there on these federally managed lands. What we didn't have was the remedy. And Danny, we met Danny and Stephanie at a seminar in Globe, Arizona. And Danny was facing the very same thing that we were facing on our ranch. They came at gunpoint and stole his cattle. And they were putting his mother and father through the paces. The government was harassing them. And so Danny, instead of worrying about the property rights end of it, because he felt that he could get that information from Dad and from other people who'd researched, he went and researched the remedy. And he took his year of law school and went back to the law library and started researching the remedies on how these guys are able to bring these cases forward and how to defeat them. And I will just tell you, he's one of the most well-researched, I've been around attorneys for a long time, and he's one of the most well-researched non-attorneys you will ever meet ethically. He's just dead on. He is intellectually honest, and he doesn't tell you anything he hasn't researched. But through his research and what we've learned through some of this litigation, we are putting all of that together in the Liberty and Property Rights Coalition to help, hopefully, help out other other property owners avail of their property rights. And so I just want to encourage you to listen to him because his expertise is beyond. I'm always amazed at it. So anyway, I hope you have enjoyed that. With that, I think that's it.